Yes, you were going to draw some threads together, I think.
Yes, I was, my lord. Having taken you to the salient points in the evidence, I was just going to deal briefly with what we say the correct approach for the judge to have taken was. And we say that the correct approach is, as he set out in his first and second judgments, that he was right to say that he should weigh the evidence and assess the inherent probabilities, but without placing reliance on the recollection of the witnesses. And in doing that, the question he should have asked himself is, which of two things was more likely? Was it more likely that in 2010 Mr. Bell clearly understood and relied upon LA Inc. having ceased to have an interest, but then by 2012 and onwards he'd completely forgotten about that reliance? Or alternatively, is it more likely that what he told the Californian court in 2012 on oath, told his lawyers in the English court in sworn evidence and verified documents 2015 to 17 is the best guide to belief in 2010? And the judge respectfully should have borne in mind that if the position is anywhere between those two, as regards Mr. Bell's belief in 2010, i.e. a lack of clear understanding, then the claim should have failed. And there is respectfully a lack of real grappling with those propositions in either judgment, but particularly the second judgment. My submission is that what is not a reasonable or sustainable conclusion is that a fog of confusion descended only between 2010 and 2012, so that Mr. Bell had a clear understanding in 2010, but then suddenly in 2012 and onwards he was confused. And I say that for two reasons. First of all, because 2 years isn't very long. This was an important thing. It's highly unlikely that he would just have forgotten what he thought in 2010. But also because what he says in 2012 and subsequently, with respect, isn't really confused. And I would say that one only gets to even the confusion explanation, which for the reasons I've submitted and Mr. Buck has submitted wouldn't actually help Mr. Bell, but one really only gets to that if one presupposes a couple of things. One is that the so-called Frenkel disavowal is something that must have been understood as intended to and having a legal effect. And secondly, that Mr. Bell must, in the first instance, have interpreted it as having such a legal effect and terminating Inc.'s interest. If one takes away those presuppositions for which there is no positive evidence, the judge didn't need an explanation of confusion or anything else, because there just was no positive evidence that Mr. Bell ever thought in the first place that the interest had been lost. So one gets a sort of constructed reality or explanation for which there is no real evidence or no usable evidence, even applying the standards the judge identified for himself. So that, in my submission, is where one ends up on reliance. In relation to unconscionability, my lords have...
Just before you move on, you said that there was no usable evidence. I've rather assumed from the judge's two judgments that Mr. Bell did give evidence beforehand at the trial to the effect that that's what he understood. So your submission comes to, but he should have just ignored what Mr. Bell said in oral evidence, is that right?
No, my submission comes to, the judge concluded rightly in his judgment, I think it was paragraph 45, that he couldn't place reliance on the oral evidence of any of the main witnesses.
But it's quite common for judges to say, I don't find X a reliable witness.
Yes.
But that doesn't mean you just ignore everything they say in the witness box. Sometimes even unreliable witnesses say one or two things which you think have the ring of truth. And that's a phrase the judge picks up when dealing with this point.
Of course, but here one has a very extreme position, because having articulated that general conclusion about the evidence and its reliability or otherwise, one then has the position where, in order to reach this conclusion, one has to prefer a piece of oral evidence on the main point which is entirely unsupported by any contemporaneous documents or anything else, over a whole series of documents, including solemn formal documents, which point diametrically in the opposite direction. So while I quite accept my Lord's point that a judge can nevertheless say, well, bits of the oral evidence seem to be right, in the context of this particular case and this particular issue, in my submission, that's not really sustainable to say, well, I don't rely generally on the witness's oral evidence, but I do rely on it on the one key point where it's contradicted by all the documents. Ultimately, that's the decision this court has to make. But in my submission, it's not really a tenable approach to say that piece of evidence, uncorroborated, can be relied on in that way.
Do we have Mr. Bell's witness statement and cross-examination in these proceedings?
We have a witness statement in these proceedings, which is at tab 13 for supplementary articles. And I suspect page 125 and onwards where one would work. And so it begins at paragraph 25. He talks about the telephone conversation. He says he didn't give detailed thought about what the strict legal position was.
In paragraph 73 of the judgment, the judge looks as if he is quoting from the witness statement. Can you show us the passage which he's quoting from? Or possibly summarising.
I think it would be 53 of the witness statement. That's what contains the phrase warring partners, so that's page 130.
Yes, I would have resigned, shut it down, etc.
Yes, he says, if I had thought that LA UK was still going to be co-owned between myself and the two warring partners.
So does Mr. Bell in this witness statement address all his inconsistent statements in the period 2012 to 2017, or was that simply dealt with in cross-examination?
He does address at least some of them. He addresses the 2016 letter at paragraph 74 and onwards. Paragraph 70 onwards, he talks about, yes, the genesis of the 2015 claim. But he doesn't there deal with the deposition evidence.
Nor presumably his evidence before Deputy Judge Tipple.
No. So at 83, for example, he said, what is more, LA Inc. could at that stage have sought to assert an interest in LA UK, upon which I would have clarified, as I did at trial, that after 2010, Ari and I understood ourselves to be the undisputed legal and beneficial shareholders in LA UK. Well, with the greatest respect, you've seen his evidence at trial, and that he certainly didn't clarify anything to that effect. Indeed, he was clear in quite the opposite direction. And the judge doesn't, in the second judgment in these proceedings, the judge doesn't really grapple with this. He just says, at paragraph 76, that Mr. Bell became highly confused as to the legal consequences. But my submission would be that none of this really is confusion. It is more in the nature of approbation and reprobation.
Where does he say in this witness statement what his belief was as to the effect of the Frenkel disavowal?
That was slightly earlier, I think it was possibly
Paragraph
25 maybe?
29 and 30.
Yes, it begins at 25 and then he says, I thought Rome meant he was giving up any direct interest that he had in LA UK in terms of its ownership and profits. When I say directly, I thought he would not say he had a right to receive profits.
Even though Mr. Bell was making payments in 2012.
But what he doesn't say there is he doesn't say, certainly in that paragraph, I thought that that meant that Inc. was no longer a shareholder. Then at 30 he says, I believe Roman would not cause LA Inc. to assert any rights in LA UK in the future. But none of this says, I would submit clearly, even in these proceedings, that he had a clear understanding that Inc. had ceased to be the shareholder. But even if he were, even if this were interpreted in that way, one comes back to the question of, which is the fundamental question of why the judge should put any weight on this self-serving account a decade later over what had been said in the documents much more clearly and much more contemporaneously. Yeah. So that's the question, really. Then in terms of unconscionability, my lords have the point which was touched upon before the short adjournment about approbation and reprobation, and whether it can be said to be unconscionable for Inc. to rely on rights in circumstances where Mr. Bell, as of certainly 2012, appeared to be acknowledging those rights. What makes it unconscionable for Inc. to continue to assert that which Mr. Bell repeatedly conceded Inc. had, and indeed relied upon Inc. having, in order to defeat a different claim by Mr. Frenkel? There's a fundamental question about unconscionability in that regard. And that is a question that the judge touched on in relation to unconscionability in the context of late cheese, but not the context of proprietary estoppel. So if one looks at his paragraph 83 and following, so 84, for example, these are reasons he's giving why late cheese doesn't work as against Inc. And his point is that LA UK and Mr. Bell did not make it very clear in 2010 or for some years afterwards that they regarded LA Inc.'s interests to have ceased. that is respectfully a significant understatement. What they actually did was repeatedly insist that LA Inc.'s interest subsisted. But there is an inconsistency, I would submit, between that approach in the context of late cheese and the approach to unconscionability in the context of proprietary estoppel. Because if that's a good reason, which it is, why late cheese doesn't work, it ought to be a good reason why it's not unconscionable for Inc. to stand on its rights in relation to the shareholding in proprietary estoppel as well.
But the cause of the suggested cause of the unconscionability is different in the two equitable principles. With late cheese, it's the fact that you've delayed, which has led somebody to change their position, which amounts to late cheese, and he's dealing there with the question of delay. And is there a good reason for the delay? He says there are good reasons for the delay. Whereas the proprietary estoppel, assuming that his factual findings are sustainable, is you said something in 2010 and I acted on it to my detriment then, and that raises the estoppel then. That's got nothing to do with delay. So the unconscionability has got a quite different source, doesn't it? So,
well, it has a different source, but they're both contingent on the same thing, which is a belief which is acted upon that the person has, to put it colloquially, gone away. Hence the late cheese decisions like Fisher and Brooker, which say that mere passage of time is not enough. It has to be based on a belief. And so, in my submission, the judge's point that it was never said that Inc.'s rights had been lost, and indeed quite the contrary, is a reason why it's not unconscionable for Inc. to assert its rights now. And again, this is not something that Mr. Bell ever suggested in those intervening years. So that's the additional points on unconscionability. In relation to implied term, I can be very brief. There are 3 points only. The first point is a point which Mr. Buck has made, so I won't labour, but the contractual and commercial relationship between a company and its shareholder is legally and economically distinct from a shareholding relationship. And the obvious example which has parallels here is somebody who participates in the foundation of a company, say some kind of startup, who takes a substantial shareholding and is also employed as an executive. If he or she leaves their employment or is dismissed, or the terms on which they provide their services are changed, for example, they go from being an executive director to being a consultant, there's no working assumption that they automatically forfeit their interest as a shareholder. That is something that can be commercially agreed and provided for, and some companies do, for example, have leave which do that sort of thing. But it's not standard, and it's certainly not obvious or necessary that where a relationship changes, one assumes that the shareholding changes as a result. And the amplification of that point is that there are at least 2 examples in this very case of the parties saying that they understood and agreed that shareholding and other economic rights would not necessarily go hand in hand. The first is the initial agreement, where they agree to split shareholding 50-50 but profits 51-49. The other is the Inc.'s sum point that your lordship will remember from this morning, where Mr. Bell's whole argument was that the shareholdings hadn't changed, but the money was now going to be paid to Mr. Lyampert rather than split between Mr. Lyampert and Mr. Frenkel. So that's point 1. The second important point in relation to implied term is that it needs to be obvious or necessary for business efficacy, not merely that there be an implied term, but that it is obvious what the implied term will be. And even if one assumed that the 2010 agreement might be a reason for some change in shareholding, it is not by any means obvious or necessary that the shareholding would change in the way the respondents now contend for, and His Honour Judge Jarman found. The trading relationship, albeit on different terms, remained a trading relationship between LA UK and LA Inc. And that's very important. Mr. Bell may or may not have considered himself now to be dealing on a personal level with Mr. Liampert as the relevant natural persons, but on any view there was still a contractual and trading relationship between UK and Inc., the entity. And that must be right, because it wasn't Mr. Liampert who owned the computer equipment and so on, it was Inc. So even if one were to accept the proposition that if you cease trading, the shareholding somehow falls away, that relationship hadn't ceased. It had changed. But why does the change in the relationship mean that suddenly Mr. Liampert personally should become the shareholder rather than Inc.? And there is a sort of a point 2b in that point, which is that this is, of course, if it happened as the respondents say and as the judge concluded, a self-dealing transaction on the part of Mr. Liampert. What he is agreeing is that Inc.'s 50% should be given up and he himself should get 50% instead. And of course that's something which happens without Mr. Frenkel's agreement. Whatever Mr. Frenkel did or didn't say about disappearing over the hills, it's very clear from the context that he did not intend or desire to enrich Mr. Liampert. So why should it be assumed as necessary or obvious that a director of a company who owes it fiduciary duties would have and did agree to enter into a self-dealing transaction where in effect he takes its proprietary interest? That's not something that either the court or an officious bystander, if I can resurrect them, would naturally infer from that set of events.
Isn't that the second stage of the 2010 arrangements? The first stage, which is sufficient to create the proprietary estoppel, if the judge's findings stand, is the Frenkel disavowal. I don't want anything more to do with this company, it's yours. And that leaves Mr. Bell free to do what he likes with UK. He could keep it all for himself if he wanted, or he could give some of it, or 50% of it, to Mr. Liampert. But at the stage of the Frenkel disavowal and Mr. Bell's reliance on it, the proprietary estoppel is complete, isn't it?
The point I was making here was principally directed at implied term rather than proprietary estoppel.
Yes.
An implied term is to do with not only how the interest is lost, but where it goes, and that was the point that I was making.
So the implied term is implicit in the 2010 arrangements as a whole. Well, that's the argument.
That's the argument, and we say, well, why is it implicit?
Yes, I see.
Given that the position is that Inc. is the trading counterparty, why is it assumed merely because one of Inc.'s shareholders has said he doesn't want anything to do with it, albeit as a matter of law he still remains a shareholder of Inc.? Why does that mean that the shareholding somehow magically passes to Mr. Liampert? Or it's to be inferred that that obviously or necessarily happens when the trading relationship continues to be with Inc.?
Yes.
And then the third and final point is the point I made this morning, and therefore won't go into again, but it is the evidential point that the proof of the pudding is in the eating, and it's quite apparent from what Mr. Bell said in the subsequent years that he didn't consider it either necessary or obvious that Inc. should lose the shareholding and Mr. Liampert should inherit it. To the contrary, he considered, as you saw, for example, in his pleading, that it was perfectly workable to have an arrangement by which Inc. remained the shareholder. And so, for the judge and the respondents to be right on implied term, they would have to be able to explain to you why it was necessary or obvious that that couldn't work. And the only possible inference is that Mr. Liampert should become the shareholder personally. And in my submission, that just doesn't work. Unless I can assist further, those are my submissions.
Thank you very much.
Afternoon, Mills. I'll start first, obviously, with the proprietary estoppel. And there are really 2 points put against me in relation to reliance. There's a separate point about unconscionability. In relation to reliance, the first point, Mr. Buck's point, is that the judgment is inconsistent. And the second point, which is really Mr. Barden's point, I think, is that, and I think he has to and does go so far as to say that the finding that Mr. Bell relied upon the Frenkel disavowal is one which no reasonable judge could have made. That is obviously a separate point from the inconsistency point. So dealing with the inconsistency point, there's a question, obviously, as to how far any inconsistency takes Malone and Friends, because the inconsistency isn't necessarily resolved by keeping the finding that Malone and Friends want and rejecting the other. Indeed, we say that the judge's finding in relation to proprietary estoppel is clear and reasoned and based on the evidence and should be upheld, whatever else happens. But, importantly, there is in fact no inconsistency in the judge's judgment. And Malone and Friends really say that the judgment says something that, in fact, it doesn't say. You will search in vain for any finding anywhere in the judgment that in 2010, Mr. Bell thought that LA Inc. did remain an owner of LA UK, or that in 2010, Mr. Bell did not think that anything about the ownership was changing. Those findings are simply not in the judgment. And your lordships do, in our submission, have to focus on the findings made in the judgment that's under appeal. And obviously, of course, Jarman 1, if I can call it that, is, as it were, incorporated by reference. But obviously, Miss Tipples was dealing with something different. And it is this judgment that one has to focus on. And it's really, it all boils down, the inconsistency point, to the meaning of paragraph 45 in the judge's judgment under appeal. In my submission, that's on page 212. The judge says that the inconsistencies, and he's referred to the inconsistencies, which are all the points that Mr. Barden makes above in paragraphs 42 to 44, the inconsistencies caused him to doubt that as part of the 2010 agreement, Mr. Bell and Mr. Liampert discussed expressly the share ownership of UK. And it's more likely that what they focused on was the business of the UK going forward and how the profits would be divided. in our submission, what the judge was saying there was that if Mr. Bell and Mr. Liampert had expressly agreed that they were to own LA UK 50-50, they'd sat down and had a discussion about that and said, well, this is how we're going to do it going forward, then one or both of them, probably both of them, would have remembered that and would have said so. And would have said so on all the occasions since when evidence was given. The fact that they didn't and that there was confusion about that led the judge to infer that there wasn't such a discussion. But it doesn't follow from that that Mr. Bell actually understood in 2010 that LA Inc. continued to have an interest in LA UK. And that is the only way in which there would be an inconsistency in this judgment. We say one has to credit the judge with some ability to reason logically and rationally. If he had found that Mr. Bell thought in 2010, if that's what he was intending by paragraph 45, that Mr. Bell thought in 2010 that LA Inc. continued to own UK, or nothing had changed, then he would be bound to have realised when he got to his findings about proprietary estoppel that he was coming to a conclusion that was inconsistent. That can't be what the judge was finding, and we say it isn't on a proper interpretation of this paragraph. And at the end of the day, the finding in relation to proprietary estoppel was based on Mr. Frenkel having said, in effect, in 2010, the company is yours. And that's a safe basis for a finding that Mr. Bell understood in 2010 that Inc. no longer claimed any interest in UK. So we say, just at a very simple level, there simply is no inconsistency in this judgment. Paragraph 45 simply does not say what Malone Friends would like it to say. Now, I ought to just deal, if I may, with a point that came up this morning, paragraph 34 of the judge's first judgment in tab 14 of the supplementary bundle on page 151. So, paragraph 34. And I think what Man from Mr. Butler was suggesting in relation to this paragraph is that it amounted to a finding that Mr. Bell was confused in 2010. And so there was a suggestion that was inconsistent with him having relied in 2010 on the Frenkel disavowal and thinking that that LA Inc. was no longer the owner, no longer had an interest. But as I read paragraph 34 of the judge's first judgment, it's really the second long sentence. In my judgment, the evidence of Mr. Bell before me and before Judge Tipples and in the deposition, emails and letters put to him, show a high degree of confusion in his own mind as to the legal position relating to the ownership and profit distribution of UK and the control of Inc. after his conversations with Mr. Frenkel in 2010. Of course, it ends with in 2010, but he's not, in my submission, saying there that Mr. Bell was confused in 2010. He's talking about the subsequent confusion.
And what subsequent confusion is that? Because Mr. Bell's position from 2012 through to 2017 was not confused in the least. He was crystal clear that Inc. was still the owner. Well, what's the confusion?
Well, the trouble with that point, and Mr. Barden has very eloquently made his points by reference to those documents. But the trouble with that point, and I was coming on to that, is that all of those submissions were, I think, more or less verbatim put to the judge at both the first trial and the second trial, and indeed were put to the Court of Appeal and in the last hearing following the first trial, when the point about abuse of process was raised. And at that point, my learned friend was saying it was an abusive process for Mr. Bell to be running these points because of what had been said previously. But that was all considered by the judge. Mr. Barden, and I don't, I'm not criticising, but he picks his key bits of the evidence, his favourite bits of the evidence that he puts. There was other evidence.
Yeah, it's one thing to say it's considered by the judge. It's another thing to say the judge gives a rational answer. Because what you're relying upon is a finding of the judge that there's, quote, a high degree of confusion. Well, the evidence we've just been shown shows no confusion at all.
I mean, there might be confusion if you're going to show us a whole load of other evidence in which he said something different. So that he's saying two different things in, for example, the 2015 proceedings. But so far, as my lord says, we've got a pretty consistent view from Mr. Bell over a period.
Well, you've got evidence of him saying things. I mean, of course, I accept what he said. He said, oh, I can't show you. I can't say that he didn't say those things. But what the judge found, and if one looks at it, it's paragraph 73 really on page 220. And this is obviously the key bit.
We're in the second judgment now, are we?
Sorry, yes, I beg your pardon. In the second. I'm jumping back because I'm trying to come to your lordship's point.
Right, sorry, where are we? Which paragraph?
73 of this.
73.
I'm very sorry, Mr. Twigger, but before we go to the second judgment,
yes,
can we just pause at the stage of the first judgment?
Yes.
Because you were addressing what the judge had said in the first judgment. And the question I was asking is, what in your submission is the judge referring to when he speaks in the first judgment about a high degree of confusion? Because at the moment, it's not clear to me what the judge can possibly have meant by that.
So, for example, if your lordship goes back to paragraph 33 in the first judgment, or perhaps one has to go actually slightly earlier than that. So paragraph 31. Before me, Mr. Bell sought to explain his earlier evidence by saying he was confused during that cross-examination, and he was referring to the pre-2010 position. He sought to explain the deposition by saying its focus was upon the incorporation of UK in 2004 was taken in stressful conditions in California. 32. I accept that the main but not sole focus of his 2012 deposition was the formation of UK, and the main but not sole focus in the 27th hearing was the 2004 agreement, and that some of the answers in both was in such context. In the exchanges summarised above, the use of the present tense in both the question and the answer seems clear when taken in isolation. So pausing there, the judge has got the point. He's seen the point that your lordships are asking me. And then he says, 33, however, his answers regarding the conversations he had with Mr. Frenkel in early 2010 are broadly consistent with what he told me about then. Moreover, in other passages, he referred to UK after 2010 as his, and to his taking it forward. The confusion arises in respect to the legal consequences rather than what Mr. Frenkel told him. As the submissions of the parties in these proceedings show, there's a stark dispute as to what is the effective law of the words which Mr. Bell ascribes to Frenkel 2010, even if they were said. So, in relation to your lordship's question, that's the confusion. He identifies the confusion and he makes the point, which, as I understand it, is the case. Obviously, I wasn't there at that trial, but there were other bits of evidence that were inconsistent with the evidence that Mr. Barton has shown. And the judge was weighing those up and took them into account.
But of course, it's not just the evidence, it was the submission that was being made on Mr. Bell's behalf before Deputy Judge Dipples.
Indeed. So, for example, I mean, just to show you, if I may, it's slightly difficult to read, but the one passage that we do have in the evidence before Ms. Tipples, as she then was, is in tab 26 in the supplemental. I apologise, this is quite difficult to read. It is on my version anyway, but you see there at page 21 on the left-hand side, and I think this is cross-examination by learned friend Mr. Barton at this point. He'll tell me if I'm wrong, I think. And you see the question at line 5, which is one of the reasons I'm sure why you didn't wind it up in 2010. You carried on with this new gloves off arrangement. And Mr. Bell said, I carried on because there was one shareholder, me, and the other shareholder, of course, was Harry. That's Mr. Lyon. And then I'm not going to read all of it. If one goes on to page 353 in the bundle, I think by this stage, yes, one sees in page 70 on the top right, Mr. Bell was being cross-examined by Ms. Ansell, QC as she then was, who was acting for Mr. Lionpert. And at line 15, she asked, so that happened from 2010, from that date, basically 50% of the profit that was made by a UK company was given to Mr. Lionpert because he was a 50% shareholder, and you got 50% as the other 50% shareholder. And Mr. Bell said, correct. And then, for example, at page 72, line 8, this is still...
Well, just pausing there, am I understanding this correctly? Mr. Lionpert as 50% shareholder, that's in what company?
This is in Inc.
Is it? It says the profit made by the UK
this
company.
Is in UK. I'm so sorry, I'm confusing myself. So you're talking about the profit that was made in the UK company. It was given to Mr. Lionpert because he was a 50% shareholder in the UK. And you got 50, Mr. Bell got 50 as the other 50% shareholder. And so on page 72, at line 8, you didn't need to change the company documentation because whatever had been the agreement before, as from 2010, you and Mr. Lionpert had agreed to be effectively joint shareholders and directors of the company. And Mr. Bell said that's what the paperwork stated.
I'm sorry, can you give me that reference
Yes,
again?
but of course it's on page 72, starting at line 8. And the answer is at line 12. So just to follow that through, in Miss Tipples' judgment, in tab 10, paragraph 109 on page 78, she said, I accept Mr. Bell's evidence that from 2010 he understood Mr. Lionpert was entitled to 50% of the profits in the UK company as he was a 50% shareholder, and he was entitled to the other 50% of the profits as he owned the other 50% of the shares. That, he said, was what the paperwork stated. So that's a reference to the bit of cross-examination I've just shown you. As a result, there was no need to change or amend any of the documentation. He thought that, as Mr. Frenkel had said, he didn't want anything to do with the company. It was fine just to continue with the existing shareholders. Indeed, Mr. Bell's evidence was that if Mr. Frenkel had put a claim into his share at that stage, I would probably have folded the business, because I would have had 2 warring partners, which would not have been very good. He said it was possible he would have wound up the UK company. At the time, he wouldn't have regarded that as a drastic step, and so on. And I think that follows through into Ms. Tipple's conclusions on page 18. Yes, I mean, just at the bottom of page 82, paragraph 123, last line on the right-hand side, Mr. Bell accepted what he was told by Mr. Frenkel in person and over the telephone at the time, and I accept that Mr. Bell had known that Mr. Frenkel claimed an interest in the UK company. Mr. Bell would have wound the UK company up, would have set up a new company. It was over 5.5 years later that Mr. Frenkel issued the claim. In the meantime, the UK company had become and continues to be profitable. I accept what Ms. Ansell has said in her closing submissions. The result of Mr. Frenkel walking away and participation in his trade, Bell and Lampert, believing themselves to be the undisputed sole 2 shareholders in the company, used the UK company to engage in further extensive trade, putting time and resources into making it a success, and so on. So it is my submission that the evidence before Ms. Tipples was not all one way. You obviously don't have it all in front of you, but it was in front of the judge. And so hence, in my submission, the judge's reference to confusion. The evidence was, in some places, seemed to be saying one thing and in some places saying the other. But Ms. Tipples accepted what Mr. Bell had said, and so did the judge. So, for example, if I can come back to the first Jarman judgment, if I can call it that, at tab 14. So paragraph 31 I've shown you already, but this is dealing with the deposition. And Mr. Bell explained that to the judge by saying its focus was on the incorporation of the UK in 2004 and so on. So the judge was alive to the points. He'd heard the evidence, he'd seen the evidence about that and considered that. My learned friend relied this morning on Mr. Frenkel's requests for payment. Your lordships remember the text exchange. But no payment was ever made. I think Lord Justice Arnold said at one point that there was payment, but there wasn't any payment. There were just requests made. And there was evidence about that. And if your lordships look at His Honour Judge Jarman's first judgment at paragraph 51, at page 155, deals there with the declaration that he'd been asked to sign, and you see the judge says Mr. Bell didn't sign it, as he says he didn't think it was valid. Mr. Frenkel said he'd sent a similar email in May, but Bell said he didn't receive it. He also accepts that in 2012 he received emails from Mr. Frenkel asking for payments from UK, and that in response in April 2012 he asked for Mr. Frenkel's bank details. In cross-examination, Mr. Bell said he did so as a stalling tactic, and in the event no further payments were made to Inc. or Mr. Frenkel from UK. He did make
Seems a bit odd if he says he didn't sign it as he didn't think the declaration was valid, that he then went across to California, presumably voluntarily, to say exactly the same thing that was in the declaration.
I'm told he was threatened with a subpoena in relation to that. That's why he went. I take it. I understand your lordship's question.
Subpoena?
Yeah,
That wouldn't have been
what I'm told.
had any force.
Query why it would have had any force.
Yeah.
At any rate, he understood that he was obliged to go, so he went.
Of course, the Californian court could have issued letters rogatory for his evidence to be taken on commission in this country. But going to a deposition in California could only be done voluntarily.
Well, there it is. I mean, it's another point, my lords, on which there was evidence. I mean, this is really the
Right, well,
nub.
leave aside
My submission.
subpoena or voluntary.
Yeah.
And it may be that he needed to go on business to the States from time to time, so could eventually have been subpoenaed, perhaps. But it's still strange that if he thought the declaration was invalid,
Why did you say what
his
you said?
his evidence in California
No, I understand the point. Yeah.
was exactly the
I
same.
mean, I understand the point, although there's the passage that I showed you earlier in which he talked about being in a room full of lawyers and all the rest of it. And, I mean, one can say, well, don't find that very convincing or whatever, but the point I'm making is that the judge heard that evidence. Mr. Barden certainly asked all those questions, and the judge evaluated that evidence and came to the conclusion that Mr. Bell...
Being in a room full of lawyers and swearing an oath is supposed to be conducive to telling the truth, but there you go.
Well, but your lordship can't conclude that he wasn't telling the truth. He was confused, he said. So...
The supposition is that he was telling the truth in California. But anyway, can I ask
exactly, one can go round and round.
Can I ask a different question?
Yes, of course.
Because you were trying to clear up a confusion on my part, and I'm grateful for being taken to paragraph 51. But can I just understand what's meant by the last sentence? I mean, I appreciate, of course, what it says. Mr. Bell did make payments by way of profit share and or dividends to Mr. Lionport between 2010 and 2017, and the amounts are given and they're substantial.
Yes.
But forgive me if I've completely misunderstood, but those payments must have been in recognition of Inc.'s position as shareholders, surely.
No.
Or Inc.'s position as the trading partner.
No.
At the very least. Because he
apart
had
from-
no personal relationship with Mr. Lionport on any of you, did he?
My lord, it's common ground, I think, that in 2010 it was at least agreed that the profits would be split 50-50 Bell Lionport. So whatever one thinks about the shareholding, there is, as I understand it, no dispute that this was pursuant to that agreement. So that bit can't tell one anything about the belief about the ownership position. And my own friends say the fact that the profits have been agreed to be split that way doesn't tell you anything about the ownership. I mean, obviously we say it tells you a lot about the ownership. It shows exactly what the parties understood, and that's the basis of the implied term. But even if we're wrong about that, those payments don't tell you anything about whether Inc. was still a share. So those are examples of situations which there were, or evidence which went the other way, as it were, to the evidence that Mr. Barden showed you. And I'm not in a position to be able to show you all of that because we don't have all of the evidence in the bundles. And if Malone Friend were going to succeed in persuading you that this was a conclusion that no reasonable judge could come to, then in my submission they'd have to show you all the evidence. They'd have to show you Mr. Bell's transcript, the transcript of his evidence, and all the documents that were before the judge. And of course, once one gets into that, one sees the problem, which is just you're being asked to rehear the case without having heard any evidence from Mr. Bell or anyone. And then, in relation to what was said in the 2015 proceedings, and of course, the learned judge understood all the points that Mr. Barden made to him and was making to you this morning. The basis of the finding in paragraph 45, which learned from Mr. Buck says is the foundation of his inconsistency argument, was the subsequent conduct, as Malone Friends call it, these inconsistencies. And so the judge was fully alive to that and actually made findings in Malone Friends' favour as a result of that evidence. And he dealt with it also in the context of proprietary estoppel. So I'm coming back, if I may, to the judgment under appeal now, the second judgment. But at paragraph 71 on page 220, one sees, the judge says, the focus on this issue, that's the reliance issue, was rather upon whether Mr. Bell relied upon those assurances to his detriment. Unsurprisingly, Mr. Buck, supported by Mr. Barden, submits that in light of the subsequent conduct of Mr. Bell in engaging with Mr. Frenkel's request for payments and his inconsistent indications in the proceedings and the 2016 letter, cannot be the case that Mr. Bell understood these assurances in the way that he says, or that he relied upon them at all, let alone to his detriment. So the judge has got the point, if I can put it that way. He's seen all these documents, and he's focused on them. And then yes, I'm so sorry. I should have shown you this before. I don't know if you still have the first Jarman judgment open. Sorry. At page 155, tab 14, paragraph 52. That deals with the 31st August letter, about halfway through the paragraph. He said in that context, in the letter from solicitors acting for UK and Mr. Bell, dated 31st August, was stated that Inc. was the correct and legal and beneficial owner of 51% of the shares. Before me, Mr. Bell maintained the letter was or should have been referring to the pre-2010 position. There were other assertions on his behalf in that correspondence, which suggested that it was he and Mr. Lionput who were the beneficial shareholders. Now, I can't show you that correspondence, it's not in the bundle, but that is another point at which there was evidence before the judge to contrary effect to that Mr. Barden has shown you. So fundamentally, it was a...
So what, the solicitors completely got the wrong end of the stick, did they, when they wrote the letter?
I'm not sure I can comment on that, my lord. And obviously the letter says what it says, and it's consistent with the pleading as you've seen. So there was a confused position there, but you've also seen that Ms. Tipples accepted the evidence that Bell and Lionput thought they were 50% shareholders after 2010. So, I mean, of course, this is part of the problem. It's a little unfair to the judge in some ways to say that he's not sort of dealt with it rationally. He'd got a body of sort of confused bits of evidence which he had to try and work his way through, and he relied in our submission entirely properly on his assessment of Mr. Bell in cross-examination. That's what he said in paragraph 73 and 74. And indeed, he relied, one sees at the end of paragraph 73, that he also relied on the evidence Mr. Lyon put. He said the latter gave evidence in support of this part of Mr. Bell's evidence, and said it has the ring of truth about it. So, at the end of the day, it's a credibility issue. It's not the kind of issue that, with respect, this court is in a good position to make findings about. The judge has dealt with it, and it cannot, in our submission, be said that he dealt with it in a way in which no reasonable judge could have dealt with it. Just ought to deal with the point that's been raised that Malone and friends say that, I think Mr. Barden said the judge didn't apply his own test, as it were. And Mr. Barden said in his skeleton, paragraph 6b, that the judge acknowledged that such a finding could only arise from agreed facts and documentary evidence. And I think he said something similar, to your lordships, earlier, that he'd said he would decide these points without regard to the witnesses. But actually, that's not, actually, my lord, before you put that bundle away, I might just go back to it.
Too late.
If that's the supplemental bundle. But that's not what the judge said. So if you look at the first judgment, paragraph 45, what he actually said was, whilst each of the main witnesses sought to discredit those aligned against him, there are substantial credibility or reliability issues as to the evidence of each of the main witnesses with virtually no independent corroboration. In those circumstances, the undisputed or incontrovertible facts, the proper inferences to be drawn from them, and the inherent likelihoods assume a particular importance. He didn't say, I'm going to disregard anything other than the documents or inferences that I can draw from them. And indeed, as your lordships know, there's no rule that just because you find a witness unreliable in some respects, that you disregard his evidence in all respects. And there's a further point, which I think one of your lordships made this morning, which is that the judge did not find Mr. Bell to be dishonest. He simply found that he was unreliable. That's in paragraph 35 in the same judgment. Yes, paragraph 35. In my judgment, there's no sufficient justification to infer that he was deliberately setting out to mislead the court then or now. That was his finding. But he says he's going to adopt a cautious approach, which is entirely reasonable. So we say really that's the end of it in relation to the points my friend Mr. Barden raises. He's raised them very skillfully and eloquently, but he's raised them skillfully and eloquently before the judge twice. And the judge has reached the conclusions that he's reached, having heard the evidence. And it's as simple as that, really. It's not open to this court, we submit, to go behind that. And certainly not possible for your lordships to make findings one way or the other without having heard the evidence. Then when one comes back to the findings about proprietary estoppel and reliance, we say that they're perfectly proper.
Just before you move on, can you help me on this? Is it correct, as we were told this morning, that at the hearing that led to the second judgment, which was in March 2022, there was no evidence at all. It was pure submission.
Yes.
And therefore, when the judge states in paragraph 74 of his second judgment that evidence has the ring of truth to it, that must be based upon his assessment of the transcript, unless we're supposing that he's relying upon his personal recollections of the evidence given to him in January 2021, that is to say, approximately 14 months earlier.
Yes, yes. Well, he says, as he refers to cross-examination in paragraph 73, yes, that must be cross-examination at the first hearing, first trial.
Right. So do you submit that the judge's assessment of the witnesses second time around can be any different to what he said the first time around?
No. Obviously, he will have looked at the transcript. He'll have had it there in front of him and been shown it. But it doesn't follow that he had no recollection of his impression of the witnesses on the first occasion. And certainly, well, speaking for myself, when one reads a transcript, things come back to you, and you remember what you were thinking at the time. So, I don't.
Would you accept that he wouldn't have had the same degree of advantage second time around as he had the first time?
I think one has to accept that rule, yes.
Yeah. All right. Thank you.
So I was just going to come on and deal very briefly with the findings in relation to proprietary estoppel, which in and of themselves we say are well reasoned and
Can I put the supplementary bundle away now?
I think so, Lord.
I will.
Yes.
We'll
I haven't got
see.
any more references for the moment. Thank you. I was going to look at the second judgment, page 219, starting at paragraph 69. And so paragraph 69, of course, is a paragraph dealing with the quality of the assurance and what Mr. Bell is likely to have reasonably understood. Insofar as he concludes that Mr. Bell is likely reasonably to have understood the Frenkel disavowal to mean that Inc. would not seek to rely upon the 2004 agreement as the beneficial interest of Inc. in UK, we say that's entirely unsurprising, given that one of the things that Mr. Frenkel said was the company's yours, you can do what you like with it. And in those circumstances, we say it's an unremarkable finding that the judge makes. I think Malone and friends have a point about this paragraph, because I think it's said that Mr. Bell's concern was just that Mr. Frenkel would disappear over the hill, I think is the way Malone and friend put it, and that didn't require any change in ownership. But of course, that's obviously not right. Mr. Bell knew that Mr. Frenkel was the co-owner of Inc. He knew that Inc. He knew that Mr. Frenkel and Mr. Lionput had fallen out big time, as it were, and he knew, therefore, that if Inc. remained involved, then there was going to be potential problems, as indeed has happened in this case. So we say that paragraph, it's impossible to criticise. Paragraph 70, I think a point may be taken, certainly taken in Mr. Buck's skeleton, that the first sentence about corporate identity is difficult to follow, but we say that's just it's an obvious and good point by the judge. And Mr. Bell, of course, couldn't have been thinking in terms of Salomon and Salomon. He wouldn't have been thinking probably in terms of legal and beneficial ownership or anything like that, or dispositions of equitable interests. He couldn't have been thinking about anything like that. He probably wouldn't have been thinking in terms of transfer of shares, because there were no shares that needed to be transferred. Mr. Bell and Mr. Lionput were the two registered holders of the two shares. So there was bound to be a sort of penumbra of uncertainty about his thoughts, and that's all the judge is getting at when he's talking about, it's not surprising he didn't understand it in terms of corporate identity. And then there's the point in that same paragraph about seeing Inc. and Mr. Lionput as interchangeable. Again, there's nothing very surprising there. Mr. Bell was, or rather UK, was continuing to deal with Mr. Lionput as Inc. They were continuing to trade together, and at that point, Mr. Bell saw that relationship as potentially very important. It had been a very big part of the ongoing business. That's the context in which he saw Mr. Lionput and Inc. as interchangeable, but it doesn't have any relevance to what he thought about whether Inc. continued to own or had an ownership interest in LA UK.
I'm still puzzled by this, and I take the point that you made earlier, which I confess I've forgotten, that as you rightly pointed out, part of the 2010 agreement was that it was agreed that the trading profits would be split 50-50 between Mr. Bell and Mr. Lionput. Fine, I understand that. And I quite understand how, in those circumstances, as the judge finds, Mr. Bell can have seen Inc. and Lionput as interchangeable. But I'm a little struggling as to why you say that's got no relevance to Inc.'s ownership of UK.
No,
because doesn't it tend to suggest that Mr. Bell's thought process was that things carried on? The only thing that changed was that Mr. Frenkel had disappeared off the scene, and de facto Mr. Lionput was in charge, in sole control of Inc. And Inc. remained as it's retained its shareholding in UK.
Well, in my submission, that's not what Mr. Bell's evidence about seeing Mr. Lionput and Inc. as interchangeable was about. Because if one reads the second sentence of paragraph 70, nor is it surprising that, as he later recalled, he then saw Inc. and Mr. Lionput as interchangeable, given the fact that Mr. Lionput assured him that despite Mr. Frenkel seeking to dissolve Inc. and taking his staff to a new company, he, Mr. Lionput, would carry on with Inc. as best he could. So that's in the context of the trading relationship. And he sees Mr. Lionput as the person to deal with, as Inc., buying and selling the goods that they were buying and selling. But the fact that they were continuing to trade together, and for those purposes he saw Mr. Lionput as, in effect, the emanation of Inc., that doesn't tell you anything in our submission about what Mr. Bell thought about ownership. It's just about trading. And that's the context of that remark. And that's why the judge then says neither of these facts individually or taken together are sufficient to impact upon Mr. Bell's reasonable understanding of what the Frenkel disavowal. And then we have the paragraphs on the next page that we've already looked at, the paragraphs dealing with the subsequent conduct, as my own friend calls it, and that's the expression that the judge used. Paragraph 71, paragraph 72, the judge said you've got to look at Mr. Bell's position at the moment the assurance failed to be performed, and I think Mr. Buck this morning accepted that the judge was right to look at it that way. We say obviously was. And then paragraph 73, 74, you get the crucial evidence about Mr. Bell's reliance, what he thought and his reliance. And then at the end of 74, top of page 221, again, he comes back to the subsequent conduct Mr. Buck and Mr. Barden submit that by 2011-2012 it was clear that Mr. Frenkel was not walking away, and Mr. Bell continued to observe the 2010 agreement and didn't resign from UK. But once the 2010 agreement was made with Mr. Lionput on that basis and acted upon successfully for a year or two, it would be more difficult for Mr. Bell to walk away. Now, I think the point's made, I'm not sure Mr. Buck made it this morning, but I think it's made in his skeleton that the UK, LA UK, had not been particularly successful for that year or two, by which I think he means profitable. But in my submission, that's not really what the judge is getting at. What he's saying is that the new arrangement, once the old arrangement about profit sharing had come to an end, and the arrangement about preferential terms and so on, trading on preferential terms, once that had come to an end, there'd been a couple of years of UK dealing with the gloves off, which I think was Mr. Bell's expression. They were trading in competition, as it were, and that had worked. So that's all the judge is saying there. He's not saying they've been particularly hugely profitable by that point. But obviously by that stage, Mr. Bell and Mr. Lionput have been running the company together and building up its business. And in our submission, perfectly logical for the judge to have said, well, things are different at that point. So that's that. Then in paragraph 76, I mean, again, it's the point about the subsequent conduct, and the judge makes the point that that didn't impact upon the detrimental reliance in 2010. So what the judge was ultimately saying was that Mr. Bell relied on the Frenkel disavowal in 2010. And the evidence about what happened afterwards simply doesn't affect that conclusion.
He does find reliance in 2010 in the way that you suggest. I understand what you say about that. And he does say something about the position changing by 2012 when they've been working on the company for a bit. But is that the judge's surmise, or is it Mr. Bell's evidence that the position had changed by 2012 so that it was then too late to think about walking away in the way that he says he would have done in 2010?
I think we think it's the judge's surmise.
Yes.
Yes, but
where does he
or
get that
inference is perhaps the way I'd put it. But
where does he get it from, if it is?
Well, in my submission, it's just inference from what happened. They were trading together and continued on trading together, and it would have been more difficult at that point.
Well, it's just a way to try and explain the subsequent conduct in a way which has no foundation in evidence, isn't it?
It's not really. I'm not sure it's really explaining the subsequent conduct. Mr. Lord, it's explaining why the subsequent conduct doesn't really matter. The point, as I understand it, is it said, well, Mr. Bell said he relied because he didn't set up a new company straight away, and the judge finds that he did rely on that way, and that's also what Ms. Tipples found, as far as that's relevant. And then what's said is, well, he can't have relied on that because later it became clear that Mr. Frenkel wasn't. And so it must follow that if that had mattered to him, he would have walked away at that point.
Well, the judge says it would be more difficult for Mr. Bell to walk away in 2012.
Yeah.
He says it wasn't dealt with in any great detail in the evidence before me, but what I'm asking is whether that was really just the judge's speculation or whether there was an evidential basis.
No, well, we don't have all the evidence, but we can look at that.
All right.
I suspect it's inference, but
Yes. Okay.
we'll check.
Thank you very much.
So was just checking my notes, but I think I've covered it in a slightly different order from that in which I was planning to deal with your Lordship's questions first. But I think I've covered everything that I wanted to say about reliance. I did just want to touch on unconscionability very briefly.
Yes.
Certainly both proprietary estoppel and leches require the defendant's conduct to be unconscionable. But the relevant conduct is different in each case. And in proprietary estoppel, the unconscionability derives from the person who's made a promise or assurance going back on it after the claimant has relied on it. And just to make that point good, and to show your Lordships a relatively recent case, might actually go to an authority, which I'm not sure we've done yet today, but the guest and guest authority, which is at tab 27, and I think that's probably volume 3 for your Lordships.
Well, I have been looking at the advocate's certificate and wondering how it could possibly have been signed, that we needed to refer to all these authorities, but if we're going to at least one of them, then let's start. Yes, where do you want to go?
So guest and guest, tab 27.
It's called 4, in fact.
Beg your pardon.
It's in fact volume 4.
Oh, I'm so sorry. Well, I was given a list of numbers. I apologise if I've got them wrong. So guest and guest really is a case about remedy. It was about whether when you're looking at the remedy for proprietary estoppel, the remedy is to fulfil the expectation that's been encouraged, or whether it was aimed at refunding the reliance loss. And the majority, with the Lord Briggs giving the main judgment, went for the first option. It was aimed at fulfilling the expectation. But I just wanted to show you a very brief passage on paragraphs 8 following on 1048, page 1048 in the bundle, and that is, for those who don't have page numbers, page 917 internal judgment. So Lord Briggs, at the very top of the page, letter A, just at the end of the middle of the second line, says it's worthwhile first to look at the problem from the perspective of first principles free from authority. As I've already said, the remedy afforded under the label of proprietary estoppel is there to eliminate or at least mitigate the affront to conscience constituted by a decision by the maker of a non-contractual promise or assurance about property upon which the recipient has relied to their detriment to go back on it. Although part of the same doctrine, I can leave aside the cases about the informal assurance was a supposed existing right, because this case is about a promise of future interest, no more or no less. The equitable wrong, if that's the right word, is not making the promise in the first place. In almost all the cases, and certainly this one, the promise was genuinely made and in complete good faith, etc. Nor is the detrimental reliance to be classified as harm in any conventional sense. It's usually something freely and willingly undertaken. And then at paragraph 10, nonetheless, the detriment is relevant to both the arising of the equity and to the remedy. Without reliant detriment, there's simply no equity at all. This reflects the notion it's the reliant detriment which makes it unconscionable for the promisor to go back on his promise. Detriment is relevant to remedy because a slavish enforcement of the promise may be so completely disproportionate to the detriment that it goes much further than necessary to put right the unconscionability inherent in the repudiation of the promise. So I show you that just to make good the submission that the unconscionability in relation to proprietary estoppel is it's somebody going back on the promise they've made in circumstances where that would result in the person who's relied on it suffering a detriment. And we say the judge's finding in relation to unconscionability in paragraph 77 of his judgment is therefore spot on, where he says, in the light of the substantial success of UK in the meantime in which ink played no part and took no risk, in my judgment it's unconscionable of ink now to assert a 51% beneficial ownership in the UK so as to give it control. So that is the detriment that will be suffered as a result of Mr. Bell having relied on the assurance in 2010. That's what makes it unconscionable for the promisor to go back on his promise. That is completely different from the unconscionability in relation to laches. In laches, the defendant's conduct is not unconscionable because he's going back on a promise. There's no promise involved. The unconscionability arises because the defendant does nothing over a long period of time, but knows all the time that the claimant is acting on the assumption that the defendant doesn't have any rights or isn't going to assert any rights. And so it's the defendant's knowledge that's the key factor. And what the judge is doing in paragraphs 84 and 85 of his judgment is saying that Inc. didn't have such knowledge over the relevant period as to make it unconscionable for it to assert its rights now, because the things that were said by Mr. Bell and so on did not make it clear to Inc. that UK and Mr. Bell did not accept that Inc. still had an interest. And so those two types of unconscionability, you can't, it's not like a finding of pure fact when one says this is unconscionable. You can't say the finding of fact that it's unconscionable in paragraph A and the finding that it wasn't unconscionable in paragraph B are inconsistent because they're dealing with completely different things. So, my Lord, I think that's all I want to say about unconscionability, and therefore all I want to say about the proprietary estoppel point, unless I can help you any further on that. And of course, if you agree with us about that, then that's the end of it. One doesn't need to consider anything further. The implied term only arises, the issue about the implied term that my learned friends have addressed you on, only arises because we have raised a cross appeal in relation to the constructive trust point based on the judge's finding that there was an agreement, a term of which was that the ownership interests of Inc. were going to be transferred to Mr. Bell and Mr. Lyon. Now, so far as the legal principles are concerned, my own friend said this morning that there isn't much between us, and I think he's right about that. I'm certainly not going to say to your lordships that you shouldn't deal with this on the basis of an implied term in the normal Marks and Spencer type way, but I do nevertheless say that one is here dealing with an oral agreement, and that when one's dealing with an oral agreement, it's not quite the same as the 70-page lease or whatever it was in the Marks and Spencer case that was being considered. And one is looking at what can be implied into a detailed written document. One is, to a perhaps greater extent, looking at what the parties were really getting at by their agreement, what is meant. Not saying that necessity isn't an important part of that, but it's just a slightly different context in the submission. But we do say that the term that the judge found in paragraph 48 was necessary for business efficacy, and the agreement would have lacked commercial coherence without it. I think that's the expression from Marks and Spencer. So paragraph 48, the finding was a necessary implication of the 2010 agreement that the shares in UK would thenceforth be held in the same way as the profits would be split, namely that each of the issued shares would be held beneficially for the person in whose name it was issued. And then, well, perhaps one needs to read all of that paragraph. The 2010 agreement was entered into on the basis of the Frenkel disavowal, his setting up a new company to compete with Inc., his steps to dissolve Inc. There were no discussions between Mr. Bell and Mr. Lionput in those circumstances as to how the UK was thenceforth to be owned and controlled. Then by agreeing to carry on the business of UK equally, the proper inference is that they are to be taken in all the circumstances as intending that ownership was also to be equal. And the background one has to bear in mind is that Mr. Frenkel and Mr. Lionput had fallen out badly, as we've seen. I think Mr. Barden in his skeleton describes Mr. Lionput as Mr. Frenkel's sworn enemy. So the feelings were certainly bitter. Mr. Frenkel was seeking to dissolve Inc. So there was bound to be a dispute.
They don't seem to have improved remarkably over the previous
I fear
12
not,
years.
Lord, I fear not. Inc. It was possible because of because of Mr. Frenkel's application to dissolve Inc. that Inc. might cease to exist altogether. The priority trading agreement between the companies was coming to an end. Inc. owed a six-figure debt to UK. And UK at that time, as we've said, was not making substantial profits. The judge described it as being in a relatively modest financial position in paragraph 58. So it's not as if anyone was thinking that something highly valuable at that stage was being given up. Of course, it's changed since, but at that time, which is the time one has to judge an implied term, it was not at all obvious that UK was going to succeed or survive at all. And importantly, Mr. Frenkel had said he didn't want anything to do with UK. Mr. Barden said, I think, earlier that Mr. Frenkel didn't consent to UK going to Mr. Lionput. But with respect, we say he did. He said, I don't want anything more to do with it. It's yours to do what you want with. He perhaps didn't realise that it would end up with Mr. Lionput. But once Mr. Bell was free to do what he wanted with it, then he could obviously give 50% of it to Mr. Lionput. So in the light of all those factors, Mr. Lionput and Mr. Bell agree to run the business of UK together. And importantly, Mr. Bell was no longer going to share the profits 50-50 with Inc. He was going to share them with Mr. Lionput instead, and that's accepted. There's no dispute that that was the agreement between them.
So why could that not have been implemented and yet the ownership stayed the same?
Just coming on to that point, my lord, to say, if Inc. had continued to own 51% of UK, then Inc. would have a majority interest and therefore control of UK. So the decisions taken by Mr. Lionput and Mr. Bell could in principle be overruled or interfered with by Inc. In fact, it's highly likely that that's what would happen given the animosity between Mr. Lionput and Mr. Frenkel.
But how so if Inc. is deadlocked?
Well, it hasn't stopped the interference now. I mean, something could happen. In this case, an administrator's been appointed in order to deal with the affairs of Inc. That's one way. Or Mr. Frenkel could just have used force of personality and said, look, I'm a co-owner of Inc. and I want to change the way this is all being run. Inc. could seek to terminate the agreement that Mr. Bell and Mr. Frenkel would share the profits 50-50. Could have insisted on being paid 51% of the distributable profits, which is in fact more than it was previously entitled to when the 2004 agreement was in place. It's not at all obvious that Inc. would have been unable to do that in these circumstances. Moreover, it could, as I think is now in effect happening, it could call for the issue of 51% of the shares to it, and then seek to sell the shares, as it's now seeking to do. And it seems most unlikely that a purchaser would be bound by the 2010 agreement to split profits and allow Mr. Lionfoot and Mr. Bell to run the business together. So we do say, in the light of all those factors, in practical terms, it was absolutely necessary for Mr. Bell and Mr. Lionfoot's agreement to continue to run UK equally and to share the profits 50-50, that the ownership should reflect their actual legal shareholdings, one each. And that Inc. therefore should no longer have any interest in UK. And I don't think Malone and Friend does now, Mr. Buck does now say that this implied term is inconsistent with the judge's findings about the 2004 agreement. That, I think, was floated in Malone and Friend's skeleton, but I think this morning he said something slightly different. But of course, the point about the 2004 agreement, it's right that the judge said that if the other parts of the 2004 deal, the profit sharing and the preferential trading, if those came to an end, he said it didn't necessarily follow from the terms of the 2004 agreement that the ownership interest would come to an end. That's right as far as that goes. But of course, everything had changed in 2010. The parties had fallen out. All the factors I've just been through had happened. And it doesn't follow, we say, that the parties couldn't make a new agreement in 2010 which decided something, in effect, different from what was decided in relation to 2004. If they'd made an express agreement in 2010, it wouldn't be open to Malone and Friends to say the parties' agreement in 2004 somehow overrode that. So the fact that it's an implied agreement shouldn't make any difference. So for all those reasons, we say the judge was right to find the implied term that he found. It was necessary as a matter of commercial, practical common sense for the ownership interests to be transferred. So that then, unless I can help you further with that point, brings me to the much more interesting subject of constructive trust. Now, Lords, the starting point for that is that it's common ground that prior to 2010, Mr. Bell held the first share on trust for himself as to 49% and for Inc. as to 51%. And Mr. Lionfoot held the second share on trust for Mr. Bell as to 49% and for Inc. as to 51%. Then there was the agreement in 2010, which was a quadripartite agreement, I think as Mr. Buck calls it, parties being Inc., UK, Mr. Bell and Mr. Lionfoot. Each of them gave consideration and received consideration for that. I'll come back to the consideration. But pursuant to the 2010 agreement, Inc. was obliged, and that's the 2010 agreement, the implied term of which we've just been talking about. So Inc. was obliged to transfer its interest in the first share to Mr. Bell and to transfer its interest in the second share to Mr. Lionfoot. And we say that follows from the judge's conclusions in paragraph 48. The shares would henceforth be held beneficially for Bell and Lionfoot. And just as an aside, the finding that the judge made in paragraphs 49 to 53 that Mr. Lionfoot had authority to bind Inc. is not appealed. So that can be taken as common ground. Mr. Bell also agreed to transfer his interest in the second share to Mr. Lionfoot as part of the agreement, but that didn't concern LA Inc. But it was nevertheless part of the consideration given by Mr. Bell. The next step is that the obligations on Inc. to transfer its interest in the first and second share involve dispositions of a subsisting equitable interest, and that would normally require writing section 53(1)(c) of the Law of Property Act 1925. However, the obligations on Inc. were specifically enforceable because they concern shares in a private company, and consideration was given. As I say, I'll come back to consideration point. The effect of those obligations being specifically enforceable is that LA Inc. was constituted an implied or constructive trustee for the transferees, with the effect that the requirement for writing in section 53(1)(c) was dispensed with by section 53(2). And we say that is simply a straightforward application of the ratio in Neville and Wilson. And so I am now going to show your lordships another authority. I think I'm right in saying this one is in volume 1 at tab 11. I've got it set.
2. Volume 2.
No, obviously the numbers I've been given are completely wrong. We can work out whose fault that is later. Anyway, Neville and Wilson. Now, the facts of Neville and Wilson are a little complicated. There was a company called UEC. I don't think it's worth me reading out the head note because it doesn't really tell you what you need to know. There's a company called UEC, which stands for Universal Engineering, Ellesmere Port Limited. And there were 1,200 preference shares and 440 ordinary shares of that company. And in 1958, all the shares of UEC were acquired by another company called JEN, and that is just J.E. Neville Limited, the Neville of the title of the case. By the beginning of 1965, 60 of the ordinary shares were held by a lady who's been referred to in the case as the widow. She was the wife of Mr. Neville, but obviously still alive during the events that we're talking about. 60 were held by the widow, and 60 were held by a gentleman called Mr. Wilson. And it was held in this case that those two individuals, the widow and Mr. Wilson, held those shares, 60 each, on trust for JEN. And all of the other shares at that stage were held by JEN itself. But in April 1965, all those other shares, other than the 120 held by the widow and Mr. Wilson, were transferred to the shareholders of JEN in proportion to their shareholdings. And you see that in the list that appears at the top of page 368 of the bundle, or page 149 internally of the case. There's a list of the various shareholders. And you'll see there that the widow was a shareholder of JEN and therefore held some of these shares. But Mr. Wilson wasn't. Mrs. Wilson, his wife, was, but Mr. Wilson wasn't. So the only shares of UEC that remained held on trust for JEN were the 120 shares held by the widow and Mr. Wilson. And then the critical transaction happened in April 1969, and one sees this on page 368, the page we're on, the quote from an affidavit, an unsworn affidavit of Mr. Hyde. It was unsworn because he died before the proceedings. And he said, in 1969, after discussions with the directors of J. Neville and the trustees of J. Neville's estate, I reported as secretary of the company we'd accumulated capital monies. I recommended that J. Neville should be liquidated and the remaining equity should be disposed of in cash between the shareholders. At the same time, I asked if I could purchase the assets of NWH Tankers, etc. 14 assets of J. Neville Limited were thereafter disposed of in cash, and the cash balances were distributed on a shareholding basis. So it was a kind of informal liquidation, if you like. But the 120 shares that were held by the widow, Mr. Wilson, were not distributed. They were forgotten about. They just remained where they were. And JEM was then struck off the register and dissolved. And by the time this case got to court, it was too late to restore it to the register. And much later, the two sides of the family fell out. That's what led to these proceedings. And the judge held that the transaction in 1965, the earlier transaction whereby all of the other shares were transferred from JEN to the shareholders, and that was not intended to and did not dispose of the 120 shares that were held by the widow and Mr. Wilson, and the Court of Appeal upheld that decision. And so the effect was that the beneficial interest in those 120 shares vested in the Crown as bonavecantia. The plaintiffs then appealed, and they raised a new argument on appeal, which is summarised on page 152 internally at letter E, where it's Lord Justice Norse giving the judgment, said, the skeleton argument prepared by Mr. Jacob for the plaintiffs was confined to the issues raised in the notice of appeal. However, early in his opening of the appeal, it became clear that he wished to raise the alternative claim to which we referred, namely that there was an agreement between the shareholders of JEN in 1969, the informal liquidation of JEN, which had the effect of disposing of its equitable interest in the 120 ordinary shares. And then, at the instigation of the court, he applied for leave to amend his notice of appeal, and so on. And the Court of Appeal held first that the informal liquidation in 1969 was expressly agreed to by the directors and implicitly agreed to by the shareholders. One sees that at the bottom of page 153 internally. So that about 4 lines from the bottom, opposite the letter H, Lord Justice North said, on a reading of paragraph 13 as a whole, we think Mr. Hyde was saying that both the recommendation and the request were agreed to by the directors and trustees. What he did not say expressly was agreed to by the shareholders. It's here that common sense comes into play. The cash proceeds of the assets referred to in paragraph 14 couldn't have been distributed without the agreement expressly by the shareholders. The only reasonable inference is that all the shareholders agreed to Mr. Hyde's recommendation. That's the starting point. They all agreed to it. Secondly, the court held it was implicit that the shareholders' agreement was intended to deal with all of the assets of JEN, known or unknown. And one sees that on page 154, starting at D, really. Here again, we think that common sense comes into play. It's an undisputed fact that after 1969, JEM was treated by all concerned as being defunct. From that, it's reasonable to infer that shareholders, in making an agreement, intend it should not be left with any assets. Put it another way, it's reasonable to infer they would have given an affirmative answer to the question whether they intended their agreement to apply to all assets, whether known or unknown. And then the court decided that the agreement therefore contemplated the division of JEN's equitable interest in the 120 shares held by the widow and Mr. Wilson amongst the shareholders in proportion to their existing shareholdings. So that's at really the paragraph beginning just above letter G. We're therefore of the opinion that in about April 1969, the shareholders of JEN entered into agreement with one another for the informal liquidation of JEN. Thus, as part of it, for the division of JEN's equitable interest in the 120 ordinary shares in UEC registered in the names of the widow and Mr. Wilson amongst themselves, as Mr. Hyde put it, on a shareholdings basis. And then over the page, at the top of page 155, in consequence, JEN's equitable interest in the shares would, as the plaintiffs now claim, be divided amongst the shareholders in the proportions 104 for the trustees of the will of the testator and 4 each for the widow, Mr Neville, Mrs Hill and Mrs Wilson. The effect of the agreement, more closely analysed, was that each shareholder agreed to assign his interest in the other shares of JEN's equitable interest in exchange for the assignment by the other shareholders of their interests in his own aliquot share. And that's a sentence that one has to puzzle over, but I think it's easier if one just gives an example. I think this is also in paragraph 50 of our skeleton. But to take Mr Neville as an example, he starts out being entitled to 4 120ths of each and every one of the 120 shares that are in issue.
Why has he got any interest at all? Why does it not belong to the company?
Well, I'm coming on to that. So that is the criticism that I think a gentleman by the name of Patrick Milne makes in one of the articles, the question how it gets from the company to the shareholders in the first place. And I think the answer to that is that, what the Court of Appeal would have said, is that that's part of their implied agreement, that there would be an informal winding up. So
it's Mr Hyde's recommendation.
Yeah. Yeah, and so I think probably at 154G, we're therefore of the opinion that the shareholders entered an agreement with one another for the informal liquidation of JEN, and therefore as part of it for the division of JEN's equitable interest in the 120 shares registered in the names of the widow. So,
all right, but that's JEN's equitable interest. It's not, to take your example, Mr Neville's equitable interest.
Yeah, so there's 2 stages. So JEN's equitable interest gets divided up amongst all the shareholders, but each of them are just holding, sorry, let me start again. JEN's equitable interest is held on trust by Mr Wilson and the widow, and that equitable interest gets distributed, as it were, between all the shareholders of JEN. That's part of the agreement. And then stage 2 is that they all exchange their aliquot shares in each of the 120 shares. So Mr Neville starts with the 420ths of each and every share, and then he assigns his 420ths in 116 shares to the other shareholders in return for them transferring their interests to him, so that he ends up with 4 absolutely. That's what the sentence, the rather difficult sentence at 155B is dealing with, that second stage. And I accept there's a difficulty about the first stage, and that's what's been criticised in a number of the articles that have been written about this case. But in my submission, it just doesn't matter, because the point about section 53(1)(c) is dealing with this second stage. It's dealing with that agreement whereby all the shareholders exchange their different shares to each other to end up with absolute interests. And so, carrying on after that difficult sentence at the top of 155, Lord Justice North said, each individual agreement having been a disposition of a subsisting equitable interest, not made in writing. There then arises the question whether it was rendered ineffectual by section 53 of the LPA, which so far as material provides, and then he sets it out, disposition of an equitable interest, trust subsisting at the time of the disposition must be in writing. This section doesn't affect the creation or operation of the resulting implied or constructive trusts, and then sets out the cases in which that section has been considered. At the end of that paragraph says the question depends on a correct view of a point left open in Outred and Inland Revenue Commissions. And says the simple view of the present case is that the effect of each individual agreement was to constitute the shareholder an implied or constructive trustee for the other shareholders, so that the requirement for writing contained in subsection 1c was dispensed with by subsection 2. And he says that was the view taken by by Mr. Justice Upjohn, as he was at first instance in Outred, and then by Lord Radcliffe in the House of Lords. And then Lord Justice North considers the various judgments in Outred, and the difficulty about Outred was that that was a case where ultimately what was decided was that the relevant instrument by which the relevant transaction was completed was chargeable to stamp duty. And ultimately, their lordships decided it didn't matter whether or not the constructive trust had come into existence to transfer an interest. They said, whatever the case, this particular conveyance is chargeable to stamp duty. But along the way, various of their lordships either considered the point or didn't consider the point as to whether the oral agreement operated to pass the equitable interest by way of constructive trust. Lord Radcliffe said it did. Lords Cohen and Denning said it didn't. And Lords Keith and Jenkins expressed no view one way or the other. And what the Court of Appeal concluded in Neville and Wilson at page 157G was they say, we don't think there's anything in the speeches of the House of Lords which prevents us from holding the effect of each individual agreement was to constitute the shareholder an implied or constructive trustee for the other shareholders. In this respect, we're of the opinion, therefore, that the analysis of Lord Radcliffe, based on the proposition that a specifically enforceable agreement to assign an interest in property creates an equitable interest in the assignee, was unquestionably correct. So they go for the Radcliffe view, if I can call it that, and you'll see that set out on the previous page, 156, the quote from Lord Radcliffe, letter D. The reasoning of the whole matter, as I see it, as follows. On the 18th of June, the son owned an equitable reversionary interest in the settled shares. By his oral agreement at that date, he created in his mother an equitable interest in his reversion. So it's the subject matter of the agreement was property of which specific performance was normally decreed by the court. He thus became a trustee for her of that interest sub modo, having regard to subsection 2, section 53 of the Law of Property Act, subsection 1 of that section did not operate to prevent that trusteeship arising by operation of law. So that is the principle, and we submit that certainly at Court of Appeal level, that's the law, that's the settled law. A specifically enforceable agreement to dispose of an equitable interest doesn't require writing because of the operation of section 53(2). And insofar as my learned friend says in his responsive skeleton that the Court of Appeal got that wrong as a matter of law, and we say obviously he'll have to make those submissions to the Supreme Court, and hopefully not in this case. He relies on some dicta of Mr. Justice Chadwick, as he then was in the United Bank of Kuwait and Sahib case. But that was a case, first of all, it was first instance. Secondly, Mr. Justice Chadwick's remarks were expressly obiter. And thirdly, he said them a few months before Neville and Wilson was decided. In fact, I think it might have been a couple of years, 2 years before Neville and Wilson was decided. So that goes nowhere. And this decision's been applied at High Court level on a number of occasions. We referred to Singh and Anand and Dalkilich and Pekin in our skeleton. And we say the ratio of Neville is applied in our case, then the effect is that the disposition of LA Inc.'s equitable interest in the two shares of LA UK didn't require writing, so the 2010 agreement was effective to pass that interest to Mr. Bell and to Mr. Lyon. And also, I see the time. I do have a little bit more to say on the constructive trust issue, and I'm happy to carry on.
Well, we usually sit till 15:15.
I'll carry on.
Convenient to you, and we
Carry on.
I mean, how are we doing for time?
I don't think we'll have any difficulty finishing tomorrow.
Good. Right. Well, carry on till 4:15 if that's all right.
Quite close to the end. Absolutely. Malone Friend makes 2 points in response, as I understand it, which I just wanted to address now. Firstly, he says there can't be a new constructive trust on the facts of this case, because he says such a trust would have the result that the trustee, either Mr. Bell or Mr. Lionpert, would be holding on trust for a beneficiary, LA Inc., which was then, by virtue of the 2010 agreement, holding on constructive trust for the main trustee, i.e. Mr. Bell or Mr. Lionpert. And so it's a kind of circle. And Malone Friend says, as I understand it, that that's impermissible as a matter of law. His second point is that he says the 2010 agreement's not specifically enforceable anyway because there was no consideration. Now, on the constructive trust point, we accept, and it's obviously right, that no one can be a trustee for himself, as it were. And it's also obviously right that if someone who holds the entire beneficial interest in property conveys that interest to the legal owner, then the trust comes to an end, because the legal owner can't be holding it as trustee and beneficiary. But the question is whether the fact that the trust comes to an end, as it would in this case, means that where the beneficial owner agrees to transfer the beneficial interest pursuant to a specifically enforceable agreement, no constructive trust can arise. And we say that can't be right. It didn't cause any difficulty in the Neville and Wilson case in relation to the widow. And this is why I focused on the widow earlier. She was the trustee of 60 of the shares, as you'll recall, but she ended up owning 4 of them absolutely. And it follows that the other beneficiaries transferred their interests in those 4 shares to her. And despite the fact that she was a trustee, no writing was required, and the constructive trust analysis applied and operated without any difficulty.
The point doesn't seem to have been taken.
Of course.
And not only that, it's not even touched on even tangentially in the judgments, is it? I mean, as far you took us through it quite carefully, and to which I'm indebted. And I couldn't see any reference to that at all.
No, I mean, it wasn't argued in that case. I accept it. It's a new point. I don't think anyone's ever argued it before. So credit to Malone Friend for that. But it is a fact, nonetheless, that it didn't cause a difficulty in that case. And
you say it didn't cause a difficulty. That's because the court was oblivious to it, the point not having been raised.
Yes, I suppose I have to accept that's right, my lord. But of course, there were some fine chancery minds at work who didn't see a problem. But perhaps I can make the next point, which is that Lord Radcliffe's judgment, which the Court of Appeal in Neville and Wilson said was undoubtedly correct, would have to be wrong if Malone Friend is right. In the Outred case, as you'll recall, perhaps one ought to look at it. I'm hoping this one will be in volume 1 at tab 6. Your Lordships may recall that in Outred there was a trust of shares in a company. The trustees were Mrs. Outred and 2 other people. And she had a life interest and her son had the reversion. And the son agreed orally, this was all a scheme to try and avoid stamp duty, but the son agreed orally to transfer the reversion to her so that she would become the absolute owner. So one has really very much the same setup. You have trustee, beneficiary. Beneficiary transfers the equitable interest back up to the trustee, so the trustee will become the legal owner. The only difference between that case and our case is that there were 2 other trustees, apart from Mrs. Outred. But I can't see any reason why that should make any difference to the point that a friend argues. Lord Radcliffe's reasoning starts at page 192 of the bundle, and it's 227 internally. And you see about 2/3 down the page the reasoning of the whole matter as I see it. That's
sorry, could you give me the page again?
Sorry, my lord, it's 227 internally. And you see the paragraph beginning at the bottom 1/3 of the page. That's the extract that the Court of Appeal set out in Neville and Wilson. And then that is followed by the words 4 lines up from the bottom of the page. On June the 26th, Mrs. Outred transferred to her son the shares, which were the consideration for her acquisition of his equitable interest. On this transfer, he became in a full sense and without more the trustee of his interest for her. She was the effective owner of all outstanding equitable interests. It was thus correct to recite in the deed of release to the trustees of the settlement, which was to wind up their trust, that the trust fund was by then held upon trust for her absolutely. There was in fact no equity to the shares that could be asserted against her, and it was open to her if she wished to let the matter rest without calling for a written assignment. Giving the trustees were apprised of making the oral agreement of Mrs. Outred's satisfaction and consideration to be given by her. Trustees had no more to do than transfer their legal title to her, or as she might direct. This and no more is what they did. Now, Your Lordship may say to me again, there's no express consideration of this particular point as to whether the equitable interest being transferred back to the trustee means that there can be no constructive trust. But in this case, there weren't other interests being transferred between different people. It was just that transaction that Lord Radcliffe was considering.
You say it was conveyed to the trustee, but she was not the sole trustee. The trustee was...
No, there were 2 others.
A, B and C.
Yeah.
And although one has no difficulty with the proposition that A cannot hold on trust for A, it's not at all obvious it follows that A, B and C can't hold on trust for A.
Well, indeed, there was a decision of Court of Appeal to which I was party about a year or so ago. I'm afraid I can't remember the name of the case, but the judgment was given by Lord Justice Lewison, where we held that that rule did not apply where you have more than one trustee.
So which rule?
That a trustee can't hold on trust for
Yeah.
themselves.
Yeah, well, I mean, of course, I see that, but it is difficult to see why that means that the constructive trust analysis doesn't operate.
That's a different point. You were citing Outred for the proposition that a surrender by a beneficiary to the trustee can give rise to a constructive trust.
Yeah.
But it's not obvious to me that that's the correct analysis of Uhtred, because you have A, B, and C holding on trust as to A for life, remainder to D, and D is giving up the reversionary interest in circumstances where it is A alone that can enforce that contract, because it's the mother alone who is taking the benefit of that disposition, isn't it? It's not giving it up to trustees to hold for themselves.
No. But she becomes the effective owner of all outstanding equitable interests, as Lord Radcliffe says at the top of page 228. So, I mean, I quite accept this case doesn't, there isn't a case in my submission that addresses head-on the point my own friend makes, that a constructive trust couldn't work in this situation where you have the beneficiary in effect surrendering its interest to the trustee, as a result of which the trustee becomes the legal owner. But it is, in my submission, difficult to see why, if it works in this case, and it works in Neville and Wilson, it shouldn't work in our situation. Constructive trust is just the mechanism by which the interest gets transferred. And so,
I think you are going to have to look at Lord Justice Lewison's judgment in the case to which I just referred. I mean, it may be that the point in that case was slightly different, because I'm going entirely on memory from a year ago, or maybe even 18 months ago. And I wish I could help you further as to the name of the case or the nature of the case.
I think I have looked at it. I have a vague recollection of what you were saying, my lord, and I think I came to the conclusion it doesn't actually take the thing any further.
You may be right.
This particular point.
Yeah.
But I'll have another look overnight, of course. But the question in my submission is whether it matters, whether it makes any difference to the constructive trust analysis, just that you have one trustee, one beneficiary. The beneficiary enters into a specifically enforceable transaction to transfer the equitable interest to the trustee. Why should a constructive trust not work in that situation, which I think is my learned friend's submission, when it works in every other situation?
Your submission, I think, comes to this, that if you have A holding on trust for B, and B orally contracts for valuable consideration to dispose of it in favour of C, the disposition in favour of C gives rise to a constructive trust, as long as it's specifically enforceable, thereby carrying the beneficial interest to C. So you say, here you have A holding for B, and B orally contracts for valuable consideration to dispose of it to A. You say that's also specifically enforceable, that also carries the beneficial interest to A. It may very well be that when it arrives in A, which is once the contract is not only entered into, but there's nothing more to be done on either side,
yes.
All that's left is the transfer of the interest. At that point, it ceases to exist as a separate interest, because it's a surrender.
Yeah.
It's a contract to surrender. Your point is there's no reason why that shouldn't give rise to just as enforceable a constructive trust, because you've got a specifically enforceable contract for valuable consideration, as you would have done if it was C.
Your Lordship's put it much more eloquently than I did, but thank you. Yes, that is exactly my submission.
Well, I don't think you get it out of Neville and Wilson except sub silentio, and I certainly don't think you get it out of Uhtred.
Well, no. Well, maybe that's right. But, I mean, Neville and Wilson, yes, sub silentio may be right, but I mean, it worked in that case. I mean, the other point is the point that your Lordship just touched on, which goes back to what Lord Radcliffe said about becoming a trustee of that interest sub modo. and then becoming a trustee in the full sense when the consideration's provided. So there is a period.
Well, it's much more obvious with the normal contract for sale of land.
Exactly.
Where entering the contract makes you a qualified form of constructive trustee.
Yeah.
The vendor is a qualified form of constructive trustee for the purchaser. He doesn't become an absolute bare trustee because he's got his own interests in the purchase price and indeed possession until completion arrives. But once the purchase price is paid and the time for completion has passed and everything else has been done, he then becomes a bare trustee for the purchaser.
Exactly. And so there is this period in which there's a kind of conditional interest. And that, there's no reason why that can't exist as a constructive trust until, as you say, the conveyance is executed and everything is done and the purchase price has been paid and so on. So that's another reason why we say, my own friend's argument, ingenious though it is, can't be right. See, I have now reached 4:04. Right. And my brain is exploding, so perhaps that might be a good point to start.
Very good. All right, well, we're sitting tomorrow then at 9:45.
9:45.